Today we have Lydia Almaguer and we have Kathy LaSalle. I'm going to go ahead and let them introduce themselves briefly, and then I'll go ahead and I have a few other announcements, but then we'll start the presentation after that. Go ahead, Lydia and Kathy.
Hi, welcome everyone. My name is Lydia Almaguer. I am the Family Law Facilitator to the Ventura County Superior Court's Self-Help Clinic. I've been an attorney now for about 30 years, and I've been with the courts for about 15 years. And my primary function here at the court is to assist self-help, self-represented litigants. That is, litigants that do not have an attorney, so they can come into our center and we guide them through the process from start to finish. We do not give legal advice. We are prohibited from giving legal advice. What we do here at the center is we explain to you the law and we give you your option. That's what we do. We give out legal information, not advice. And everything right now, thanks to COVID, is by appointment only. So to make an appointment with our center, you do have to go on to our Calendly website and make an appointment.
Sure. Hello, everyone. My name's Kathy LaSalle, and I am the Deputy District Attorney assigned to the DA's Child Abduction Unit. I've also been an attorney for about 30 years. I've been in this unit for 13. And we, per statute in California, are mandated to take all actions necessary to enforce people's rights to custody. So if you're having a visitation or custody problem, we're the people that you would see to help get your rights enforced. Although we don't work for parents, we assist them and we do our work on behalf of the court. That's pretty much it in a nutshell.
Okay, again, welcome everyone. I'm not going to cover a whole lot because of the time constraints. I'm going to give you an overview of what to expect. It may be a little bit too much, but just keep in mind that if you ever have any questions regarding any of the presentations, we do answer our phones here at the Self-Help Center every Wednesday, Thursday, and Friday between 1:30 and 2:30. If you are calling our center, please make sure that you have your case number, because that way we can look you up in our system to see where you're at in the case and to be able to better give you the information that you need. So for today, again, the disclosure is basically we do not represent you. It's simply we give you legal information. I'm going to skip some of my slides because the slides that I have, we utilize in our webinar. We also offer a webinar via Zoom every Thursday. And the attorney that is currently presenting that webinar goes into how to obtain or modify a court order. She will send you the Zoom link and then send you the forms. She'll put on her presentation, and then you are allowed to ask questions at the end of the presentation. And again, that's every Thursday. I believe her RFO is at 10 o'clock. When I say RFO, that's an acronym for Request for Order, okay? So in order for a litigant, and that's what we refer to the persons that are coming in to the center who do not have legal representation. So when we're assisting the litigant, when they come into the center, one of the first questions that we'll ask is, do you have an underlying case? What do I mean by that? A lot of litigants that we get here in the center that sign up to come in for self-help assistance, they will say, yes, I need a request for order because I want custody, visitation, or child support orders. But in order to file a motion to have that issue heard in front of the judge, you must have an underlying case. And what do I mean by that? An underlying case means either you were married to mom, in which case you filed a divorce. When you file a divorce, you are given a D case number from the court. If you are not married to the mother, then you need to start out with an action to establish a parental relationship. Basically, you're saying, I am the father of this child or these children. You may or may not be on the birth certificate. I have a lot of dads coming in who are not on the birth certificate. It doesn't matter. You can come into the center and we'll go ahead and guide you on how to start that process. In that process, we can also assist you with adding your name to the child, adding, your last name to the child. But again, I'm not going to cover that process because today's focus is going to be really on how to file a custody visitation request. So just keep in mind that you can't automatically file an RFO. You do have to have an underlying case. Anytime you're reaching out to the center, please make sure that you have that case number. Your case number will start with a D, the letter D, and then 6 numbers. Right now, we're in the 4s. So it's going to be D, 4, and then, five numbers after that. Some cases have an SD case. The SD cases were cases that we had in Simi Valley. At one point, courts were hearing cases in Simi Valley. When cutbacks started to happen, we had to close down Simi Valley and everything was heard here in Ventura. So just be aware that it may be a D case or an SD case. If you do have a D case and you've opened, whether it's a divorce or whether it's a EPR, EPR is the acronym for how to establish a parental relationship. Again, irregardless of whether the father is on the child's birth certificate or not. When you come in, we will help you file what's called a request for order. You want to file a request for order only if you and mother are not able to come to an agreement regarding custody of your child or children. There are 2 types of custody. There is legal custody, which is a right to make decisions regarding the child or the children's health, education, and welfare. There's physical custody. Physical custody means with whom is a child going to live with primarily? Primarily with mom, primarily with dad. And then we also deal with visitation, parenting time. And that's what the courts look at with regards to days and times that the child is going to be with mom and be with dad. When you're filing a motion for custody visitation, make sure that you have a definite schedule that you want with the child. What do I mean by that? We have litigants who come in and say, Lydia, I want 50-50 custody. Okay, what is 50-50 custody? Well, I want to see my child on the weekend and then twice during the week. And we will inform them that is not 50-50 custody. Somewhere out there, litigants picked up, 50-50, and that's half the time, without really understanding what half the time is. 50-50 custody means just that. And it can be a variation of days and times. But the easiest way for me to explain that to you is a week with mom, a week with dad. The changes may take place on a Sunday, on a Monday, or on a Tuesday. So when you're filing your motion, make sure, number one, that the days and the time that you selected, you're able to spend that time with the child. When the child is with you, you are responsible for that child. In other words, if the child's going to school and you have the child Monday through Monday, then it is your responsibility to make sure that the child gets to school and back. So just keep that in mind when you are filing a motion that you have a specific timeshare. Basically, what you want to do in order, like I said, you have to have an underlying case to start the case. The form number that you will be filing is called the FL-300. That's the form that needs to be completed. And again, if you make an appointment with our center, we'll help you with the forms. If you don't have time to make an appointment with the center, then we now have these forms directly on our court's website. When you go onto our court's website, if you go under family law, it will tell you basically the forms that you need. If you do request for order, or if you do a divorce, it gives you the forms, it gives you access to the forms. We didn't used to have those before, but now we do. Now they're up and running at our court's website. With the forms, again, you're going to be checking the boxes that you want the court to address. The form that you fill out will have different boxes. It will have a box for custody, visitation, support, other, and you're marking the box that you want. If you want the court to address custody, visitation, and support, you're going to be marking all three boxes. Like I said, for custody and visitation, there's joint custody, there's legal custody. Legal custody is the right to make decision over your children's health, education, welfare. Physical custody is with whom are the children going to live with primarily. The goal of the state of California and of the judges here is to have the children spend as much time with both mother and father. We get here in the center fathers that come in months, sometimes years, that they have not seen their children. And what they're telling us, and we'll ask them, it's like, why is it taking you so long to come in and ask for this order? And the response sometimes is, well, mom wasn't letting me see the child, and I thought that if mom didn't let me see the child, that's the way it was going to be. I don't know where they're getting this information, but what I tell them is that is not correct. You have the same right to your child or your children that the mother does. Mom's rights are no superior to those of dad, okay? So when you complete your form, when you're filling out your form, you're marking the boxes on that FL-300 that you want the judicial officer and the mediation to address. If it's the first time that you're filing a request for order, both parents and children over the age of 6 must participate in mediation. The mediation process takes anywhere from an hour and a half to 2 hours, okay? You will be checking in. Sometimes you're given the mediation date the same date as your hearing date. The hearing date is when you go before the judge. Sometimes you're given the mediation date prior to your hearing, because mediation is really, they're backed up. So if you file a motion right now, you're looking at about 2 months to get into court. So it's because you have to go to mediation. The judges, the judicial officers will not make orders or permanent orders regarding custody and visitation until and unless mom, father, and children over the age of 6 have participated in the mediation process. The mediation process is necessary because that's the court's way, the judge's way of getting a better, clearer understanding of what is in the child's best interest. That is the law. Family Code Section 3111 says, we're going to make orders that are in the children's best interest, not what's best for mom, not what's best for dad. What is best for these kids? So the court has the parties and children go through mediation. When you report to the mediation, absent a restraining order in place, the mediators will, or the mediator that's going to mediate your case on that date, will call both parents into their office away from the children. We used to have a children's waiting room where you could bring the child and put the child there. And then the child would be there until the mediator was able to speak to the child. Currently, if you have to bring your child or your children to mediation, make sure that you are bringing with you somebody that can take care of them while the mediator is talking to the parents. Obviously, if your children are older, 13, 14, most of the times they can take care of themselves. But bring someone with you. What the mediator then does, the mediator will mediate with mom and dad, talk to them about the day-to-day and what sort of custodial timeshare they're looking for with the children. Again, this is where it's important for you to express what timeshare. Don't just say 50-50, okay? When you file your FL 300, which is your request for order, which is a form I couldn't put up for you, you will need to attach a written declaration, your written statement. Your statement is your story to the judge, to the mediator. What has been going on in these parties' lives? You start out, I'm here because basically I want custodial timeshare with our children. I have been involved in our kids' life from the beginning. Mom and I separated. She's refusing to let me see the kids, or mom and I can't agree on a time that's best for these kids. So we have to come to the court and let a judge decide. Keep in mind that you and mom can decide and can enter into any agreement regarding your kids. The courts do not get involved. The courts do not want to get involved. The best persons to make decisions regarding these children are you and mom. The courts make orders when dad wants A and mom wants B. Okay, so that's, and you would have to give a brief story. Your declaration can be 10 pages long. There is a maximum of 10 pages. It needs to be, it doesn't have to be typed up as long as it's legible. I've seen some declarations where I'll tell the litigants, the judge is not going to be able to make heads or tails of this because they can't read it. And it must be in English, okay? The judges don't read. We have our mediators who are bilingual, but the judges are not. So your declaration has to be in English. Your declaration can be 10 pages long, and your declaration should contain information regarding a brief history of your relationship with mom, with kids, what sort of parenting, co-parenting skills did you and mom share, and what is it that brings you to the court today. Don't get caught up in your declaration with regards to, oh, mom's boyfriend, unless it's relevant to the child. It, like I've told litigants who come into the center, oh, well, she's dating this guy and that guy. It doesn't matter. If the children are well taken care of and mom is taking care of the kids, same thing with you. If you're taking care of the kids, that's irrelevant. The courts are focusing in on what is in the children's best interest. What's in the children's best interest is to spend as much time with mom and with dad. That's in their best interest. The state of California only gets involved when the children are in danger. Then you have them being placed in foster care because neither mom nor dad can take care of the kids, but that's something completely different because we've had that issue come in with parents who have teenagers, and the teenagers are constantly in trouble, juvenile hall. We have them showing up with their kids here. I want to turn my child over to the state. I can't handle my child anymore. No, it doesn't work that way. The only way a child gets removed from a parent is if the child is in danger. The parent or parents are being neglectful. But other than that, again, you and mom can come to whatever agreement. If you don't, fill out your RFO along with your declaration. Once that is completed, once your forms are completed, you will need to make 2 copies, an original and 2 copies. Your original must be 2-hole punched at the top. If it's not, the clerks will reject it. So the original, the 2-hole punch, stays with the court. When you go to file, there's going to be a filing fee. The filing fee is $90. Your original filing fee is going to be a lot higher. So if you're filing for divorce, it's $435. If you're filing an EPR, it's $435, unless you qualify for a fee waiver. If you are low income, Medi-Cal, SSI, a WIC, food stamps, you automatically qualify for a fee waiver. So you don't have to pay those filing fees. But once you file, the clerk of the court will then give you a date to come back. Again, the mediation date may be the same date as your hearing date. The mediation date may be a different date than your hearing date, but the mediation generally takes place first. Once you go to mediation, if you come to an agreement with the mother in mediation, the mediator will write up that agreement for you. It's very detailed. It covers lots of different sections as far as travel, days, times, legal custody, physical custody. You will sign the mediation agreement, so will the other party. The mediator will then sign the mediation agreement. You're sent back to the judge. You go to court, and the judge signs that agreement, and that's it. The judge doesn't even hear the case. If there is no agreement at mediation, the mediator will make a recommendation to the court. And the mediator generally bases it off of conversing with the parties and conversing with the child. When the mediator speaks with the children, they're out of the presence of mom and dad. You don't get to hear what the child says. The child basically, and it's not like, oh, who do you want to go with? That's not what the mediators do. The mediators try to assess the situation, try to get a pattern for what sort of relationship connection they have with both parents. And based on that, the mediator will make a recommendation to the judicial officer. If there is no agreement, you will be sent into the courthouse into the courtroom before your judicial officer. We have 5 different courtrooms that address that here in Ventura. You don't know which courtroom you're going to be assigned to until you file your first case. When you file your DISO or you file your EPR, that's when you're assigned a case number, and that's when you're assigned your judicial officer. But if you do not agree with the mediator, you go in front of your judge. The judge will ask each of the parents, Dad, do you agree or do you disagree with the mediator's recommendation? And you can state whether you agree or disagree. The same question will be asked of mom. And then the judge will hear from both parties. If the judge believes it's necessary to put on a hearing, to have a hearing, they will do that. They will go ahead and have a hearing. At the hearing, you can bring in witnesses. At the hearing, you can subpoena the mediator to come in and testify. You will have to subpoena the mediator if you want them to testify at the hearing. And then after the judge hears all of the information, all of the evidence that's presented, the judge may go with the mediator's recommendation or may not go with the mediator's recommendation. Here in Ventura County, we do have the judge can take into consideration the mediator's recommendation. Other counties, the parties go to mediation, and the judge never gets to see what the mediator recommended. But keep in mind that if you are in mediation, and I'm bringing this up because it has come up here in the center, where we talk to litigants afterwards that are unhappy with their agreement, and I will ask them, but you agreed to this, Dad, you agreed, did you sign this? Yes. Well, you agreed to this. Well, I thought I didn't have a choice. And that's where you really need to get informed. You don't have to agree with the mediator's recommendation. The mediators cannot make orders. The only ones that can make orders are the judicial officers. So when you go into court, you present your hearing, the judge will make an order, okay? Sometimes, and that order, keep in mind that a custody visitation order and child support is always modifiable until the child has turned the age of 18. So you can always come back. We see situations in where mom and dad are constantly, it's like a revolving door here at the courthouse. You don't want to do that. You really don't. Because it's not beneficial to these children to have to go through this process, especially if you are having them come into court because they're over the age of 6. Now you're pulling them from school, you're bringing them to the courthouse, which is not a nice place to be. I mean, I work here, but if you've ever been to the courthouse, it can get very hectic. A lot of people, just with the fact of knowing that they have to go to court, get nervous, get stressed. So if you can avoid that, we always encourage that at all costs for you and mom to come to an agreement. Keep in mind that here at the center, if you and mom are on talking terms, are communicating, are co-parenting, you can always come into the center and we can help you write up a parentage agreement, a custody visitation order that outlines the kids, how much time dad is going to be spending with them, how much time mom is going to be spending with them. You both sign that agreement. It's called an agreement or stipulation. Once it's signed by both of you, if you're here at the center, we walk it back to the judicial officer. The judicial officer will sign it, and then you file it, and that's it. You don't have to come to mediation. You don't have to go before the judge, and you have an enforceable custody visitation order. So it can be that simple, or it can be very complicated, where parties are definitely not getting along and the judges are left with no other option than to say any and all communication regarding the minor children is going to be through talking parents. You don't want that. You don't want that. But sometimes the courts are not really left with any other option because the parents are just too far apart. There are also times where the courts may appoint an attorney for the child when it's a really contentious and difficult case, because the courts or the judges can't determine what's really going on. So they will appoint an attorney to talk to represent the minor child's side. And there's also cases where you may need to come in and file what's called an emergency ex parte motion. Those motions are filed when one of the parents believes that imminent irreparable harm is going to happen to this child. And so the parent says, I need to get into court within 24 hours. And the courts will allow you to get into court within 24 hours without going to mediation because it's an emergency. The fact that you have not seen your child for 2 months, or mom has withheld the child for 3 months, not allowing you to see the child, is not an emergency. Again, imminent, irreparable harm is happening. will happen to this child unless and until this court makes a custody visitation order. And they'll make it on a temporary basis. The other times we see ex parte hearings being filed is when one of the parents is hiding the child, keeping the child. You don't know where the child is. Mom or dad have taken off with the child. And that's when Kathy LaSalle's office, the district attorney's office, comes into play. So Kathy, if you want to take over from here and explain that process.
Hello again. I'm Kathy LaSalle. I work for the DA's Child Abduction Unit. Our acronym that the courts use is DACARU. Everybody over there seems to know that stands for our unit. And there's often times where you might be going to Lydia and asking them to help you figure out how to get DACARU appointed. What we do in a nutshell is child custody enforcement. You know, child abduction unit sounds super exciting, and we do recover children that are abducted. We had a child last month that was abducted from the country of Poland and brought here, and we went through the process that was required in order to get the child returned to her father in Poland. But most of our child custody enforcement deals with people who both live in our county, who simply have a difficult time for one reason or another following the custody order. We are mandated to use all civil and criminal means to enforce parents' rights to custody. So we oftentimes get orders to just enforce a visitation order, but sometimes we're ordered to locate and recover missing children. The types of custodians that we assist are parents, guardians that might have a guardianship order out of probate court. And we also work on behalf of Child Protective Services. And those are cases where children have been abused or neglected. The children have been removed from their parents. Parent might take off with them, and the court orders us to locate them and recover the child and return the child to CPS. We have mandated duties, so we enforce custody and visitation orders. We locate, serve, and procure the appearance of a parent and the child. We always ask that parents in those scenarios prove to the court that they've made good faith effort on their own to locate and find that parent. You know, you can hire a process server. Here it would be the sheriff's department is what's most commonly used. And we expect that you do that. Our unit only becomes involved when you truly have no idea where that person is, or when they're in a location and need to be made to come to court. And then we locate and recover and return children to either the jurisdiction of the court or to their lawful custodian. We also occasionally file criminal charges, but that's, I would say, about 3% of the time. Our policy is to take the least aggressive means and work from there, trying to get everybody back on track for the sake of the child. Children have a right to have both parents in their lives, and that's something that the statute says. It's also something that is our office's policy. We work on 4 kinds of cases: visitations, abductions, criminal cases, and good cause. And I'm going to go through those briefly. A visitation is one where there's an order in place that says where the child should be at a certain time, and one parent or the other isn't complying with that. They're not meeting at the McDonald's at 2 o'clock. And so a lot of times what parents do is contact the local police agency and make a report, an incident report. And that's something that we encourage parents to do, because then you have a record, an objective record, where somebody else also can confirm you were there, the other person wasn't. Especially when those visitations happen on a Saturday or a Sunday, because we are open 8 to 5 Monday through Friday. And so we will gather that information. And when it becomes egregious enough, we have had cases where even visitation situations would escalate into a criminal case, because we've made it very clear that we expect the person to follow the order and they're not. And it's the last means available to us to make them do what the court order says. Abductions are just that. It's where we don't know where the child is. We include just orders to locate and serve parties. Sometimes a parent will have moved to another state, and we're involved in locating them and serving them with the paperwork and making them come back. We consider that to be an abduction, even though it doesn't rise to the level of us actually going and physically removing the child from that parent. Criminal cases I'll go over in a bit, as well as good causes. So our general rule is for civil enforcement, so those are for the visitation and the abductions where we haven't filed a crime, that we want to be appointed before we do anything more than make a phone call. So a parent might have a custody order, that was issued last month, and we make a phone call and say, listen, we're looking at this order. It was just issued a month ago. We expect you to follow the order. And the parent might say, yeah, but last week something happened and this is why we're not going to follow it. That requires that we make more than a phone call now because this person's telling us no. So we would ask that the person who wants our help getting this other party to follow the order, go to court and get us appointed. That necessarily lets the judge know what's going on because we work on behalf of the court. We want to make sure that what we're doing is in compliance with what the court intends. And so, just like I said, our role in civil enforcement, now in criminal, we prosecute people just like any other crime. But in civil enforcement, we work on behalf of either the family law judge or the dependency court judge or the probate judge. Our most important responsibility as we go about this is to act in the manner that's in the best interests of the children. There's a lot of times that a court who issues an order may not know information that we discover. And so we may elect to not automatically enforce that. We instead would elect to go back and then let the judge know, update everybody, get everybody back to court so that everybody feels like that person who's making the custody order is fully informed. And our system does have limitations. All of the courts I've just mentioned have huge calendars. You'll see when you go in on an ex parte hearing, they start at 11:30 and there's 5 of them. You're not going to get a chance to talk. The court is only going to consider what's on paper. Some of the judges don't even come out on the bench. That's how short emergencies are handled. And so it's really important that in those situations, our unit do all that we can to make sure that we do as much investigating to make sure if there's something more that needs to be told, we do it. Agencies meant to protect children have huge caseloads. CPS, swamped. The police, they're going to go out and they don't know the history. They don't know if this is the most recent custody order. It's very likely they're going to tell a parent this is a civil matter. They'll take an incident report. If the police agency even knows our unit exists, because they do, but not all of them do, not all the police officers, some new patrol officer may not know, they're not going to know to refer you to us. And so that is another limitation in our system. Also, there is not an automatic right to have an attorney in family law cases or in probate cases. That's true even for the children. The children didn't pick these parents. They're not in any way in control of what's going on. It's up to their parents to be able to be adult enough and mature enough to be able to realize that it's not about me, it's about these kids. And if both parents have that attitude, you've got a much better shot at getting through to the age of 18 without the child being horribly traumatized. Because once our unit is involved, the majority of those cases involve kids who really have had a rough patch, not to mention the parents, but these kids really suffer. And we see that on a daily basis here. Most parents have limitations. We're dealing with parents who are sad or angry, have drug addiction problems, have financial issues, aren't here in the country legally, have language issues. All of those limitations that a parent brings to the situation make it even harder. And the courts don't have the same access to the criminal histories that our unit does. One time we had a parent who got convicted in the morning of child abuse come in with a custody order that they got at 1:30 out of the domestic violence court, who just didn't know about the criminal case and gave full custody to that dad because the court decided it on the papers. And the papers were a bunch of baloney. And so luckily, we didn't just go by the papers. We looked into this person and realized that that had just happened. And we were able to inform the court and change the order quickly, because we felt like if this judge had known the full details, that order would not have been issued, and we were correct. Courts can be easily misled, and so our unit, working on behalf of the court, views that as one of our main roles, is to make sure we inform the court of what's going on. We have limitations and things that we don't handle. We don't handle stranger abductions. That's a police department situation that has nothing to do with parental abduction or family abduction, because we do handle some family stuff. We don't handle runaways, teenagers who take off with their friends. It's not their friends that are depriving the parent of their custody rights. We don't handle unwilling teenagers, I've written here, but even children. You know, there's some 12-year-olds that are as tall as I am who ran away out the window last night and who tell their parent to, you know, F off and all this stuff. And if the parents aren't able to control that kid, we certainly are not. And sometimes the court appoints our unit in those cases, and we, out of the get-go, let parents know of our limitations and let you know that we'll make a call. We'll try to get everybody back for example, mom and dad and the kid in a parking lot, and dad, you're up. It's your turn to make this kid get in the car. And if you can't, we can't. And we don't give legal advice. We cannot practice law without a license, which is one of the things that might involve, is telling you what forms to file. And we can't communicate with any party that's represented by an attorney without getting that attorney's permission. We don't enforce anything other than visitation or custody. So if mom's not giving them the medicine at the right time or not giving you the address where they're at, that's not our unit that handles that. We do expect everyone who comes seeking our help to do everything that you can to help yourself. So to educate yourself, if we ask you to do something, we expect you to do it. If you don't, we may not continue with your case. So that's important to keep in mind. What you should expect. We're going to ask you a lot of questions, and we're going to be asking those questions of other sources as we go about our job. Is this child in danger? Is our first and foremost question. Is there an enforceable custody order? When I'm thinking of custody orders, I want to know, is it the most recent court order? Because an order issued last month might have been changed last week. Is the order so old that the circumstances have changed? The order's 2 years old, and none of the kids were in school then. So it was going back and forth between here and, you know, San Luis Obispo County, and now the kid's in school. We can't enforce that. It's too old to enforce. It's not practical. Are there competing orders? Did mom get an order in Arizona and dad has an order here? Or we've even seen it here in Santa Barbara, and the two courts weren't told about it by the party. When you file something, you're supposed to say whether you had a case somewhere else that involves custody of these kids, but some people don't do that. Are there orders that are temporary and that were issued without due process? So we have a case, lots of them, where a parent will get an ex parte emergency order on the paperwork and will not have given the other parent notice because it's too risky. They might abduct the kid or they might harm the child. And a court issues orders, but the other parent didn't even know about that. Those we view very cautiously before we act, because judges can issue orders. They have full immunity. Law enforcement does not have that. Parents have a constitutional right to the care and custody of their children. And before we act on something that drastic, you can be darn sure that we're going to do a thorough investigation. Is the order an out-of-state order? Because there's a process. A judge in Arizona has no authority to order any law enforcement officer here in California to do anything. If the order from Arizona would first have to be registered here, and then there must be, once that order is enforced, there must be a post-deprivation hearing here before the child can be removed and sent back to Arizona. Same would be true in the reverse. So we would have a parent that might come here, like we see these cases, especially people in the military. The order was issued in Kansas and now they're here for vacation with dad. And they're expecting, if they show up with this Kansas order, that we're going to immediately act. Doesn't happen that way. There's a process involved that generally involves at least a week's period of time because there's a registration process. We have to give them notice, and then we have a post-deprivation hearing. And we're likely not going to give that kid, even if the parent from out of state wins, we're not going to give that kid to that parent until that post-deprivation hearing happens, because what if that parent takes off and the other parent didn't get their post-deprivation hearing, and now we're on the hook civilly that we let that kid go. So it's important that you understand that if you get our unit involved, we're going to follow the procedures that are in place to make sure that we dot all our I's and cross all our T's. For out-of-state orders and out-of-county orders, we want certified copies, because I have access pretty quickly to getting orders here in our county, but if they're from another county, I do not. And so getting me a certified copy will make us be able to help you that much more quickly. The terms of the orders. This is important for us. If an order is confusing, or if an order is subject to more than one interpretation, or if the parties are allowed to agree on some other terms than what's in writing, enforcement of those other terms, or even if what's in writing, can be very difficult. And I'll give you a couple of examples. So here's one that we had last week. The child shall reside primarily with the mother, and the father shall have parenting time with the father no less than 1 week per month, consisting of 3 consecutive overnights followed by 24 hours, and then 3 more consecutive nights. Now, what 3 consecutive nights out of the month are we going to be enforcing? Is it going to be the first week or the second week or the third week? If your order doesn't tell me where those children are supposed to be on August 9th, I can't enforce that. We would require that you go back to court and get clarification. We might make a phone call and say, Mom, you know, the golden rule, you got to treat him like you want to be treated, those sort of things. But if you get an order like this, like I know Lydia was talking about, you can do a parental, agreement and just file it with the court. If your order is very vague or not something that we know where that kid is supposed to be, you're going to be going back to court. Also, I notice here, all visits are going to take place in the city where mother resides. Up at the top, you see that she's living in Virginia. How do I know where she lives and in what city? So that's another vague thing that is really not anything that law enforcement can enforce. And so it's great if you have a relationship with the other parent where you know that you're going to be able to be cool and she's going to be cool and it's all, but if that's not the situation, you want to read your order 3 times after the mediator writes it and play defense attorney, so to speak, and figure out what loopholes are there, because I guarantee you, if you guys are having a fight or if there's a new girlfriend or boyfriend involved, that's when the difficulties are going to arise. Here's another one that I was talking about. So this one at least tells us every weekend from Thursday at 5 until Sunday at 5. That's better. But any other times as agreed upon between the parties, people agree on the phone. They agree on a text message. They manipulate their text messages so that they can change them. Did you know there's an app you can delete a whole part of it and completely trick everybody about a conversation that happened? We learned that the hard way in one case. So think about, I'm showing this because if you're in the process of getting an order, it's important that you look at it with a fine-tooth comb. The typical process, if you come to us for help, you're going to contact us and we're going to do an initial intake. You're going to call our main line or you're going to step into our lobby, and the person who deals with you initially is going to get just the basic facts to make sure that we can actually help. Then you're going to complete a complaint form. It's in detail. We don't want, a lot of people write NA, which means not applicable, on almost every question. I wouldn't be asking the question if I didn't want you to answer it. If it doesn't apply, you can put, or if it's not true, you can put no, you can put yes, and you can give me details because I'm going to ask you anyway, and you're just slowing the process down. This is signed under penalty of perjury. If you lie, this is like making a false police report, and we take that seriously. So we encourage you to make sure I'm going to find out the good, the bad, and the ugly anyway. You might as well tell us right out of the get-go. We want generally a photo of the taking parent and the child. This is especially true when they're missing. And we want all relevant documents that we ask you to get us. Sometimes we want to see what everybody's filed in the case prior to that and so forth, so that we can kind of get a frame of where we're at with this and what approach to take with the other side. We would ask that you go back and get us appointed if we're going to have to do anything more than make a phone call. We're going to then meet with you and do a more in-depth interview. We generally would make, unless it's an emergency, we would make an appointment to do that. It might be a situation where we're able to resolve it without that. Once we're appointed, once we show the order to the other side, they might just say, okay, I'm going to do it. But if not, we're going to be interviewing you. And we're going to be asking you to provide us with the supporting evidence, the text messages, the other stuff that you have, the Facebooks, the Instagram stuff, witnesses you might know of. If it's an international case, they've abducted your child to Mexico or to some other country that's a member of the Hague, we're going to be asking you to complete a Hague application. And then we're going to ask you to keep us in tune. I can't tell you how many times a parent gets their kid back. They come in, it's an emergency on Friday, they get their kid back on Sunday, and then they don't bother to call and tell us. So Monday we're working, and by Tuesday when we're calling to check in, and maybe we aren't even going to check in then because we're assuming they would certainly call us and let us know, then we find out they haven't. So that's very important, and we ask everybody to do that. Our complaint form, this is a screenshot of the Ventura County District Attorney's website. You can find our complaint form. This is the front page where that little red arrow is. That's the media center. And then once you click on that, down at the bottom under publications, that's our child abduction complaint form. We also have on our website a brochure, which I think you're also going to be given access to through this training. But the brochure explains what our limitations are, kind of goes through what I'm going through right now with you. And you can certainly even, if you know somebody who's going through a problem like this, turn them on to that and they can look there. That's a good starting place, is to just read that to see if what you're going through is something we can help with. We might also ask you, if your kid's missing, to file a missing persons report. The police are mandated to take that report within 2 hours. Parental abductions are considered to be at-risk abductions. The police are mandated to take that report in 2 hours. What that does is that gets your kid and the taking parent into the system. We may file criminal charges. It's a crime to maliciously take, entice, keep, withhold, conceal any child with the intent to detain or conceal that child from a lawful custodian. So there's two code sections. 278 can be a misdemeanor or felony punishable by 2, 3, or 4 years in jail. 278.5 is a misdemeanor or felony punishable by 16 months, 2 or 3 years. Good cause is something that we also deal with. And what that is an affirmative defense. If a lawful custodian, so the person who claims good cause has to have a right to custody. If a lawful custodian disobeys the custody order, takes or conceals the child or withholds the child, if they have a reasonable, good faith belief that the child will be in danger if the order is followed, so given to the other side, or the custodian, the lawful custodian, has been a victim of domestic violence, and same thing, has a good faith belief the child's going to be in danger if the order is followed, they can claim good cause. The requirements are that they make a report to our office. They have to do that within 10 days of not following the order. And they have to provide us with the information that I listed here, the name, their address, their phone number. All of that is confidential. And by the way, everything that both sides give us is confidential. Our file is confidential. We cannot turn that over without an order from the judge. So keep that in mind when you're telling us things like your address and a lot of detail about what's going on. We do everything that we can to keep it confidential. We will file a declaration for significant safety things with the judge, but especially your address and phone number and that sort of thing is confidential. You also have to commence a custody proceeding within 30 days. You have to inform our office if you move or you change location of the child. So, this isn't a way to get out of custody orders permanently. What you're doing is whatever you're telling us right then and there, you're going to be telling the judge. You're going to have some explaining to do as to why you're not following that custody order. So you need to keep that in mind when you're talking about whether to claim good cause. Things that you can do, you can get a solid order. Look at Family Code Section 3048. That order or that code section talks about things that the court can consider when there's concern about parental abduction, and things that the court can order to ensure that parental abduction doesn't happen. Things like posting a bond if you're going to leave and go on vacation, especially out of the country. Different factors to be considered, different things to include in your order. And if you're not getting along with your parent or the child's parent, or if you're somebody who's from Mexico, or you know that person is, or even from another state, they don't have any ties here, look at that section, because to get an order that includes those things is valuable. Use Talking Parents or any other apps that the court orders that you use. I know Lydia was saying you don't want to be ordered to use those, but those things are good tools to have later when you're saying one thing and she's saying the other thing, and the judge is in the middle getting fed up with hearing everybody complaining and doesn't really know who to believe. If you have evidence, if you have Talking Parents, which can't be tampered with, that's a valuable tool. And pick your battles, if your kid is 14 years old and wants to stay with mom, and it's because mom's brainwashing, or it's because mom doesn't make them do their homework or whatever, that you want to bring that to the court's attention. But if you've done that and it's not working, we oftentimes tell parents, we're dealing with one right now. The kid's going to be 17 in October. That kid's going to be 18 in 14 months. Is this a battle that you want to pick because your child is aware that you're doing it too, and you may be alienating them from you, not because what you're doing is wrong, you're doing it out of love, but they're with the other parent right now, and other parents do say things about each other, and it's nasty. Divorce is nasty. Kids get tainted. So think about that, and think about the golden rule. Be the bigger person. Treat the other person like you want to be treated. That goes farther than any of the other advice you're getting today. Really think about that and try as best you can to not fall from that. Document everything that happens. Use a calendar, have a binder, be organized. Write down who you talk to, make notes. The people who do that are much more successful helping us help them than those who don't. Register your out-of-state order. If you have a custody order from South Carolina, but you haven't done anything to register it because there's a process involved. And if you want that to be enforced, it's not going to be until that registration process happens. And there's the Passport Alert Program through the U.S. State Department. Look at that. I'm giving you some online resources. That's the middle one, www.travel.state.gov. If you go on there, there's a whole section about parental abduction. There's lots of advice on how to prevent abduction. If you may not want your child to be given a passport. If they already have one, this doesn't help as much, but one of the things the family law court under 3048 can ask is that the passport be turned over to you. But this passport issuance alert program will alert you if the other side tries to get a passport for your child. I recommend you look at their website and know what it says if you're married or if the parent of your child is from out of the country. It's very valuable. Education is power, knowledge is power. You want to know, you don't know what you don't know, and you can prevent things by simply knowing how to, by going on there. And here's my contact information. This phone number is our main line. You can also go on the website and get our information there as well. Again, it's the Ventura County District Attorney's Superior Court website. I'm sorry, not Superior Court website, District Attorney's Office website. And here's our main line. My name again is Kathy LaSalle, and we have an investigator. We have an investigative assistant. We would be happy to help you if you're having problems getting custody and visitation rights enforced.